Every profession has its own jargon, and it can be confusing if you haven't gone through some formal training with it. In the world of employment law, we have legalese. Well, it's legal language with its own little spin in it. It's kind of like basic English, except for the fact that you're talking with all these new terms that you haven't used. This next section will cover a lot of this. Now, it's going to be applicable to employment law, but an awful lot of this chapter especially will give you a good background so you'd be comfortable reading any kind of a journal that would address types of legal documents because of the fact that this is all about courts, all about laws, and actually part of the process. So let's take a look as to our legalese that we have just for this course over here on how to read cases. Well, a case is a real life application of the course concepts, and when you sit down and look on how we deal with laws in the United States, and some other countries use that aspect as well. So stare decisis is really about standing by a decision. In essence, what we have are cases, some as old as 100 plus years old. We consistently apply that same principle from that case way back then at that time period into today's time period because we're building cases based upon a certain type of premise. So we call that a legal precedent. So we have a legal precedent for this over here. We're going to sit down there and refer back to that case, and that will give the regular courts the ability to sit down and make decisions that will not be overturned by other judges because it's based upon their personal opinion rather than a legal precedent. The legal precedent is the foundation for a lot of American law. It's frankly a smart move because of the fact that you can refer back to this, you can refer back to cases that have been decided on one court level and then a higher court and then finally the Supreme Court. You keep on referring back, and referring back. That way you have a basis to stand by a decision, stand by a principle, or stand by a legal precedent. So that being said, when you have an opinion, especially if it's an appeals court, you're going to have different aspects of it. You can have a majority opinion. Now, majority is not just one court, one judge, because we're referring here to appeals court or even state Supreme Courts or federal Supreme Courts. It depends who has jurisdiction over that type of law. If it's a state law, it's going to be going to a state court, and the top court in each state will be the state Supreme Court. If it's a federal law, the top court will be the United States Supreme Court. Occasionally, you'll have somebody trying to find a way to bring something that's covered by state law and they'll sneak it in with some other aspects of bringing suit over a federal issue that relates to the state law. But for the most part, you have two different types of jurisdictions going on. So whenever we have an appeal, then you have a group of judges that will weigh in and make a decision. You'll have the majority of the judges. If there's only 3 judges in the appeals court, then 2 out of 3, that would be a majority. If it's a matter of concurrence, that judgment means they're concurring with the lower court's ruling. The lower court ruled that this person is the guilty party, and then they appeal it. That court then says, we concur with that decision. That means that they are agreeing with the lower court and the appeal is denied. If they dissent against it, then you have that. You can have, in the case of the 3 judges, you might have a majority opinion and a dissenting opinion that would identify what the argument is from that one particular judge that dissented against it. Or they can sit down and send it back. So it's going to depend what they have. The interplay, U.S. Supreme Court decisions are final, period. That's it. They make a decision. Every year, the Supreme Court gets thousands. I'm not exaggerating about that. They literally get thousands of cases that want to be heard at the Supreme Court level. And then they choose cases. Typically, they'll choose around 3 cases that will be related to the same different issues. They'll clump them together and listen to them, listen to all the arguments, and then sit back and make a decision as to what the actual outcome will be. They'll make a decision, and sometimes you'll have everybody agreeing, which is actually pretty rare. You'll have a majority opinion, and then you'll have a minority opinion. But sometimes you'll have a majority opinion, but you might have this judge saying over here, these two agreeing over here, this one over here. You might have multiple different opinions as to why that judge ruled the way they did, even though it's a matter of they might be a minority or even the majority. So you'll see that type of interaction happening. And really, the state Supreme Courts, you have the same thing. When a court interprets a statute, Congress can enact a new law to change that law if interpretation is not intended. Ideally, the courts should never make law. The court should be looking on law that exists as to whether or not it's appropriate, because making law is not the court's decision. It is actually the legislature's opinion to create that law, and the court to review the legality of it by applying the principle over here of stand by a decision, or the legal precedent does that do that, and they go back to the original language as to what the legislative body said. Most cases in this text, we're going to involve with federal courts applying federal statutes. I'm going to talk a little bit more about the California aspect of it, because by golly, California has so many strange different aspects of it, it's worthwhile paying attention to. When you read a case, there's a case name, somebody sues, the defendant responds. These are called parties to litigation. And the citation, that's the book where the case report can be found. It'll have the court name and the date. Outcomes, you have a lower court affirm. You can have a higher court reverse it, or even remand it back to the lower court for further handling because they feel the lower court might have missed this concept. Well, then the lower court reconvenes and they handle that concept, and they could still appeal it back, but they want to make certain that the lower court addresses that. Really, no judge likes to have something coming out of their court reversed or remanded back. Remand is better than reverse it, but nobody wants to say, you made a mistake, which is what the appeals court is all about. So here's some terms. The plaintiff, one who brings a civil action in court. A defendant, one whom the case is brought against. The appellate. If the case is decided, then the one who brings an appeal to a higher level. The appealee, one against whom the appeal is brought. A petitioner, one who appeals the case to the Supreme Court. And the respondent, once again, whom the case is appealed at with the Supreme Court. You'll also have a book, and the book is called The Law Reporter, and that's where they have court opinions that are placed. You'll have a case citation, the volume and pages in the Law Reporter where the case opinions can be found. A lot of times on the reporting aspect of it, if there's a specific case about something, you don't want to have your case in that book because of the fact that you're setting a legal precedent. I have one case in a book. It's not actually in the court system. It's actually in an administrative jurisdiction here in California where I actually had the decision, and it's the only one I ever lost, and by golly, it got recorded too on top of that. That's not a good thing. Anyway, so then you have a motion to dismiss, where the court rejects that. Motion to dismiss. And a lot of times that's the defendant's request to the court to reject the case for some defect. Almost every case, you're going to have the motion to dismiss based upon this. So you have all that going on. Motion for summary judgment. The defendant's request to rule that this is just ridiculous. There's no tribal issues here, a fact to be decided. Almost everybody's going to file that. Those are pretty standard aspects of it. And then per curiam, a brief determination made by appeals court. A cause of action. When somebody files a case, the lawyer's job is to go through all the different things that happen and try to find out which laws were broken in the process and what can they claim that because of this over here, this is what the law is and my client was damaged. Because of this, they broke this law and my client was damaged. That's called a cause of action. I've seen the cause of actions 3 in a case. I've seen 17. The lawyer's job is to throw mud up against the wall and hope that some of it sticks. So they have a cause of action. A prima facie case is they present evidence that fits each requirement of a cause of action. So they want to sit down and have, based upon this case over here, it applies here. Based upon this case, remember what we said, stand by your decision. That's a core of our judicial system. So whenever you're working through a claim, they work for the different elements to create a prima facie case that based upon all this, this is the past precedent of law. Okay, it's a legal precedent. This is what should be the end result. And that's the attorney's job to present that. So on the legalese, stare decisis, standby decision, know that. A prima facie case, know what that is. Know what a cause of action is. And know about the concept of majority, concurrence, or dissent. Know about jurisdiction in the aspect of this is a federal jurisdiction and a state jurisdiction. In this class, we'll be talking primarily about the federal, but we will talk about the concept of state as well. So all this is the beginning of our legalese indoctrination to know some of the language that we'll be talking about for employment law. Take care.